Welcome to Dorsey and Whitney's webinar on financial and trade sanctions against Russia, the impact on your business. I'd like to introduce Kyrre Haugen, the General Manager with the Norwegian British Chamber of Commerce. Take it away, Kyrre.
Thank you very much. Hello, everyone, and welcome to this webinar, which we are co-hosting with our friends here at Dorsey and Whitney. At the Norwegian British Chamber of Commerce, which I represent, we work closely with Dorsey, and they are a much valued and long-time partner member of the NBCC. And Carsten, who is sat next to me here, serves as a director on the NBCC Council. For those of you who might not know Dorsey, they are an international law firm headquartered in Minneapolis in the US with 20 offices and approximately 600 lawyers across the US, Canada, China, Hong Kong, and here in London. Of course, you will all be aware of the recent invasion of the Ukraine and the horrific scenes that we are seeing on the news every night. From us at the NBCC, our thoughts and support are with the Ukrainian people. And at this time, as we hope that peace and normal life can return to the region as soon as possible. As you will all also be aware, Russia and those considered to be part of President Putin's inner circle have been hit by the West with the toughest package of sanctions ever imposed on any country. This started when Crimea was first annexed in 2014, but has been ramped up significantly in the last month since the invasion started in Ukraine. This has huge legal ramifications for a number of businesses that either directly or indirectly trade with or have a link to Russia. This is what we are here to run through today, and I will hand over to Carsten to introduce his colleagues who will cover this topic from respectively a US angle and from a UK and EU angle. Carsten.
Thank you, Kyrre. Yes, and I would like to reiterate what you said about Ukraine and the Ukrainian people who have our full support. And we here at Dorsey, both privately and as a firm, are taking part in a number of initiatives to provide humanitarian support where we can. Before I introduce our speakers, which is what you're all here to hear, I wanted to mention that the chat function is open on Zoom. So if you have any questions as we go along, then please put them in the chat and we will try and deal with them at the end if there is time. If there's not enough time to deal with all the questions during our allotted hour, we will endeavor to follow up individually after the session with those of you who have asked questions. So rest assured, we will follow up. Our first speaker is Larry Ward, who is a partner in Dorsey's National Security Law Group and is the head of our Seattle office. Larry's day job is to help companies involved in international trade understand and comply with the various complicated US regulatory schemes, export control, and sanctions programs in a cost-effective manner. This is to avoid monetary, criminal, and other penalties and reputational damage faced when those regulations, controls, and sanctions are violated. Needless to say, Larry has been busy in the last month, and we're delighted he has found time in his crazy schedule to be with us on Zoom here today. Over to you, Larry.
Thank you both for that introduction. And just to preface my comments today, about a month ago, my colleague Nelson Dong and I did a presentation on the US sanctions that were imposed back in February. Those sanctions have changed quite considerably, even within the last month. However, if you are interested in an in-depth presentation on US sanctions, we certainly at Dorsey can get you a copy of that presentation so that you can go in depth in these US sanctions rules that have come out recently. On the fourth slide of the PowerPoint today, I just present an overview of the US agencies that are involved in implementing US sanctions. Each of these agencies is within the presidential administration. The US State Department is the department that actually sets our US foreign policy. those folks decide on the sanctions programs that we are going to institute, and they determine individuals, entities, and others that should be targeted for sanctions. There are then two US agencies that are really responsible for administering and enforcing the sanctions programs that the presidential administration decides to implement through the State Department. The two agencies involved, and the two that we'll discuss in some detail today, are the US Treasury Department's Office of Foreign Assets Control, or OFAC for short. And that's a term that probably many of you have heard when you've heard about US sanctions. And then the other agency involved is the US Commerce Department's Bureau of Industry and Security. There's a slight difference between what these two agencies actually administer and enforce. The Treasury Department, as would make sense, actually implements economic or financial sanctions. And so it targets not only exports of goods and services, it also targets imports of goods and services, and it oftentimes targets financial systems within any given country. The Commerce Department, on the other hand, is only focused on exports of US origin items or re-exports of those US origin items. So tangible things, also software and technology. So there's a slight difference between what these two agencies regulate, but at the end of the day, they have the same chief purpose. On the next slide, I want to just look at how these sanctions have evolved over the last nearly decade. Back when Russia began its invasion into Ukraine and its annexation of Crimea, the Obama administration at the time implemented a series of executive orders. These executive orders issued by President Obama essentially outlined the sanctions that the United States was going to implement against Russia for its actions within Ukraine. During that time, the sanctions really targeted various industry sectors within the Russian economy. So these sanctions targeted financial institutions. They also targeted companies that were involved in military or defense. And importantly, they also targeted oil and gas companies, particularly those that were involved in Arctic offshore drilling. At the time that these sanctions were implemented, OFAC, which is one of those agencies that I mentioned on the prior slide, implemented a new list of targeted persons. It was referred to as the SSI list, or the Sectoral Sanctions Identifications List. And one thing you'll notice very quickly about US law is we like acronyms or shortened or abbreviated words. So this SSI list is simply a list of various persons and entities that were targeted under these original sanctions implemented by the Obama administration. And the other thing that these sanctions did was they actually imposed a comprehensive embargo on the region of Crimea. And what that means is basically all transactions with that region were off limits to US persons. On the next slide, we look at the actual regulations that implemented these sanctions, the Ukraine-related sanctions regulations. One of the biggest issues with the sanctions that were implemented back in 2014 is that many of the targeted Russian oligarchs that were subject to these sanctions were quite savvy from the business side. They understood how the sanctions programs worked, and in many cases, they were able to transfer business interests in order to avoid the sanctions impacting companies that they owned or impacting other interests that they own. OFAC implemented what is referred to as its 50% rule at that time. And what this is basically any company that is owned 50% or more by one or more sanctioned persons also must be treated as sanctioned. And so this essentially was a way that the US was trying to force the hand of these Russian oligarchs in order to get them to divest more of their ownership interest in these entities. On the next slide, then, we look at how these sanctions have evolved quite rapidly over the last month. Last year, in follow-up to the disruption that the Russian government was involved with in our elections and in our democratic system and in other elections and democratic systems across the globe, the Biden administration implemented 2 executive orders that were essentially targeting various aspects of the Russian government. They also targeted certain Russian energy export pipelines. Once Russia invaded Ukraine this year, the sanctions then got much more serious, and the Biden administration implemented 3 new executive orders, one of which targeted or set a comprehensive embargo against 2 additional regions in Ukraine that had been overtaken by Russia. And then there were 2 additional executive orders in March. Between these 3 executive orders, the Biden administration was able to authorize OFAC and the Commerce Department to implement a series of sanctions programs. On the next slide, we look at some of the ways that OFAC has actually implemented and responded to these executive orders. Since February, the Biden administration through OFAC has actually implemented sanctions against over 80 financial institutions, including 4 major Russian banks. They've targeted 13 major state and private owned companies. And then continually since February, they have been targeting various Russian individuals and various Russian cargo vessels. Even today, the Biden administration is in talks with other NATO countries and is discussing additional sanctions to be implemented. What we understand from these new sanctions is that not only will new Russian individuals be added to our sanctions lists, but there is some belief too that the United States government will also impose the possibility of secondary sanctions. What secondary sanctions are sanctions that the US can implement against foreign companies and against foreign governments for essentially trying to help the target of a US sanctions program. So if a particular country or a particular group were to transact with businesses or entities that are targeted under the OFAC sanctions, there's a possibility that OFAC could then target that company, could target that government. So that is something that's on the table today. The biggest impact of these OFAC sanctions, though, really has been on the banking system. It has led many US companies to essentially just move out of Russia entirely in terms of its business because getting paid and making payments has become too difficult under these sanctions programs. On the next slide, I just list out the various sanctions lists that OFAC now has. Each of these lists contains different entities and individuals that are targeted for the sanctions, and each of these lists operates a little differently. Under some of these sanctions programs, it is entirely off limits to do business with a sanctioned individual or entity. Under other of the sanctions, you can do certain business with these entities and individuals, but not other business. So it really gets pretty detailed pretty quickly in terms of how these sanctions operate, and it's quite difficult to navigate. And then finally, I just want to look at the impact on the Commerce Department side or the BIS side. On the next slide, I list where things stood as of 2014. So at the same time that OFAC had implemented sanctions back in 2014, the Bureau of Industry and Security did the same thing. And what they did at that time was really target the oil and gas industry. And so essentially what the US government tried to do is stop all US origin items and technology from going to support the Russian oil and gas industry. There certainly were some carve-outs for some projects that were able to continue, but they essentially tried to target this industry, tried to target the Russian economy in that way. The Bureau of Industry and Security also added a host, nearly 36 Russian companies to its entity list. And that list basically is a list of entities that US goods and technology cannot be provided to. And so that has not only an impact on US companies and US persons, but it also impacts foreign companies. If a foreign company, a Norwegian company, is receiving an item from the United States, generally speaking, that Norwegian company can't then turn around and ship that item to Russia, because that's a violation of these Commerce Department sanctions. So it is very important for foreign companies to understand the origin of the goods and technology that they have, and whether the US laws actually follow those goods and technology. And then on the final slide in my section, in the last month, the BIS has significantly expanded its own export restrictions. Again, they've targeted additional oil and gas projects, but they've targeted several other industry sectors as well. Any company involved in the defense sector, aerospace sector, and maritime sector are ones that are significantly hampered by these new BIS restrictions. Essentially, what the BIS has done now is determined that any goods and technology that are controlled for export purposes under one of 7 categories on our list of controlled goods now requires an export license to Russia. Not only do US companies have to get that sort of export license, but again, foreign companies that might have US origin items would also have to get a license from the US government before they could turn around and re-export that item to Russia. The other impact that this has had is the US government has now determined that if US origin goods and technology are involved in creating some foreign origin item, there are now restrictions on whether that foreign origin item can end up in Russia. So this has been an expansion of the way that the US sanctions work. The US government did this several years ago with respect to Huawei, the Chinese telecom company. And it essentially shut off Huawei from much of the global telecom community because of the extent and the nature of US origin goods and technology that were prevalent even in foreign origin items. So the end goal here from the US government really was not just to target shipments of US goods to Russia, but also to target shipment of many important foreign items to Russia because those foreign items involve US origin goods and technology. And then one final thing that the US government did, the BIS did through these latest sanctions, is add additional entities to another of its sanctions lists called the military end user list, that again just makes it impossible to ship US origin items to those entities without getting an export license. And the BIS has implemented what's referred to as a policy of denial, meaning you can apply for the license, but you're not going to get it. So with that, I will go ahead and turn it over to Ron to walk you through the UK and EU sanctions.
Thanks, Larry. I just wanted to quickly introduce Ron before we hand over to him. Our next speaker is Ron Moscona, who is a technology and IP partner in our London office, and many of you may know him as such. And he's also our London office's resident expert on UK and EU sanctions programs. And Ron has advised a number of clients over the last few weeks on issues relating to doing business with Russian entities and individuals that have been sanctioned, including businesses that have had dealings with Chelsea FC. And Ron is a specialist in navigating this complex and ever-changing area of the law. And with that, I'll hand over to Ron.
Thank you very much, Carsten, and thanks, Larry. Could we skip ahead with the slides, please? Okay, so thank you very much. I will be talking about the EU and the UK sanctions. And by the way, one slide back, we skipped too much. That's it. Thank you. One comment first. I would say that by and large, the US sanctions and the sanctions imposed by the EU and the UK are quite aligned, and they're quite similar. They touch mostly on the same areas of emphasis and do things in a very similar way. I think partly because of constitutional differences and differences in the way US legislation is basically being put together and imposed compared to how things are done in the EU and the UK. There are some differences, and there are some significant differences, and I will come to that and try to focus on that mainly in the area of trade sanctions that work quite differently from the EU and UK point of view than the way they work in the US, and I will get to that. But first, just as Larry did, I will start by saying a few words about how the sanctions were until February 2022, since 2014, and how they evolved in the last month. So in 2014, the UK was part of the EU, and the sanctions were imposed basically by the EU. The UK participated in them just like any other EU country. So there was no variation whatsoever between the UK and the EU. It was the same legislation. And pretty much like in the US, since 2014, a number of types of sanctions were imposed in relation to Russia and in connection with the annexation of Crimea and the intervention in the fighting in Donetsk and Luhansk in the east of Ukraine. So individuals and organizations that were directly involved in these military activities were designated for asset freezing. Asset freezing sanctions are very extreme. They freeze the assets of individuals and organizations, and including those entities that they control. Hence, things like Chelsea Football Club that is owned by a person who's now sanctioned for asset freezing, and that means that the assets of Chelsea Football Club as well are being frozen. That means that, except to the extent that licenses are granted, any activities, any financial activities or business activities of those designated persons are frozen. But since 2014, only few people of any significance were included in these asset freezing sanctions. It was mainly military people and so forth. More significant, there were sanctions, financial sanctions against key Russian banks and some key enterprises, and those were relatively light. They targeted the securities issued by those banks, and perhaps a little bit more significantly, they restricted the ability to lend money to those banks. Next, there was something which was less problematic for Russia, I think, an export ban on military goods. Russia makes its own military goods, so it wasn't particularly significant. There was a ban on supply and delivery of military goods from Russia, which was intended to make it more difficult for Russia to export its military industry. And there were export controls on dual-use items, which is nothing out of the ordinary, because generally dual-use items are subject to controls, and licenses could have been given. And there were trade sanctions, important but not particularly extensive. And as in the US, they targeted the oil and gas field and focused on a list of very fundamental articles, goods that are used in Arctic, in deep sea oil exploration and extraction, and various services and financial services related to them. There was also more extensively a complete import ban on goods originating from Crimea, That was the main response to the annexation of Crimea, and then export ban on the supply of infrastructure goods, which is a very, very large category or series of categories of articles for supply to Crimea. So again, the only extensive sanctions before 2022 were in relation specifically to Crimea, and fairly limited or not very extensive trade sanctions focusing on the oil and gas sector in Russia, but not to the extent that that Western oil and gas companies couldn't actually work in projects in Russia. They could still do that, and they got licenses as well. So if we can move to the next slide, please, and that focuses on the position since 24 February 2022, when, as we know, Russia invaded Ukraine as a whole. So by this time, the UK is no longer part of the EU, as we know. And as in most areas of life, the UK legislation continues to be very much aligned with the EU, although there are some minor variations at this point, minor variations occurring. So I would say that in relation to all of the important elements of EU and UK sanctions, they are exactly the same, still using the same language, even though now they are based on if you like, separate UK legislation, and they don't emanate from the same source. In both cases, if we compare to the US position, with a number of institutions that are involved in imposing sanctions, from the president to the Department of Commerce and so forth, both in the UK and the EU, this is dealt with through primary legislation. Very simple. This is primary or secondary legislation. Primary legislation passed by the European Commission and with the Parliament and the Council, and in the UK by the Parliament, and largely by the government that has powers to impose the sanctions under primary legislation. So I think in that respect, the formulation of the sanctions is less less influenced by structural issues, and I will get to that in a minute. So the extent of the sanctions has been dramatically expanded since 24th February. There's been a series of pieces of legislations on the 25th, 28th, the 1st and 2nd of March. During that week, a lot of new legislation was passed. Firstly, through a number of stages, the list of individuals who are designated for asset freezing has been expanded dramatically. And the first step in doing that was to actually expand the legal basis for designating people for asset freezing very significantly, because before 2020, before 24 February 2022, both on the UK side and on the EU, the government or the legislature was able to designate people for asset freezing if they were directly involved in the destabilizing of Ukraine or in military activities. Now the legal position is that the government can basically designate anyone who's got any connection with the Russian government. And indeed, in one of the last waves of designation of individuals, the UK and the EU designated all 350 odd members of the Russian Senate who voted in favor of the war. So they're all, which is if you think about it, it's quite an extraordinary thing to do. Quite significant to designate for asset freezing all of the members of the upper house of the Russian Federation, in addition to President Putin himself and most of the people around him, the political leaders of Russia, as well as pretty much all of the significant oligarchs who are controlling a lot of the Russian economy, and of course have a lot of assets outside. Now, one constitutional difference between the EU and the UK on the one hand and the US on the other hand is that the UK and the EU doesn't have or do not have qualms about banning people from travel. The US, I believe, doesn't like doing that because of constitutional considerations. In the UK and the EU, when people are designated for asset freezing, very often, and indeed in this case, they're also subject to travel bans. They're not given passports, and a lot of these oligarchs, if not all of them, have a lot of properties, sometimes very significant properties in the UK and other parts of Europe. These people cannot travel now to Europe or to the UK at all. They have to leave, and they are now facing serious trouble in that respect, and that applies to a lot of Russian politicians as well. Since the war started, the financial sanctions against Russian banks have been dramatically expanded to the extent that they're now cut off from the international payment system. And that is significant because in practice for companies that have or want to have dealings with Russia, that poses a very significant practical issue because getting payments to Russia and back from Russia is now not impossible, but very, very difficult because Russian banks cannot transfer money into Western banks. They cannot exchange currency. So they have to do it in other ways, maybe using Chinese banks. I don't know how they would do that. The sanctions were imposed not just by the EU and the UK and the US, but also by Japan in relation to its financial system, and also by Australia. So there's still vast parts of the world where these financial restrictions do not apply. But if you cannot use US, EU, UK or Japanese banks to do transactions, you are very, very much restricted. So that was only introduced in the first week of March. Another very important element on the financial side is the financial sanctions against the Central Bank of Russia and a couple of other key national financial institutions, which are now subject to prohibitions against providing these institutions with asset management and foreign exchange services, which again means that the Central Bank of Russia cannot use its foreign reserves at all. It cannot convert the money. It cannot use it. It cannot invest it. So that is extremely significant, of course. Another important element, which actually could have implications beyond the banking system, is very, very extensive prohibitions on granting loans. I will refer to that separately in a moment. Before restrictions on lending was limited to some key Russian banks. Now there are prohibitions on granting loans to anyone connected with Russia. So that is makes doing business with any companies in Russia very, very difficult. And a number of other important measures that were taken by the EU and in the UK, which I believe are not all necessarily the same in the US, is a ban on Russian ships and Russian aircraft from using the ports and airports of the UK and the EU, and also the territorial water and the territorial space of these countries. So that means Russian ships cannot deliver any goods to Europe and to the UK, and there's no Russian aircraft now flying into Europe or the UK. That applies, of course, also to, as was emphasized in the news, to the private jets of oligarchs and other corporations. There's a number of more specific issues. There's been a ban on promotion of tourism in Crimea. There's a ban imposed only by the EU so far, not by the UK, on broadcasting, including online broadcasting of Russia Today and Sputnik, two very important Kremlin-run news agencies. Russia Today is extremely popular around the world. It's a major news. It's CNN, basically, Russian CNN, run largely by Western people. but the content is very much dictated by Russia. So again, I don't think the US will impose that type of sanction because it goes against freedom of speech principles. But as I say, the EU and the UK have less qualms about these kind of things. So now the EU has a very extensive ban. So anyone who's involved in broadcasting should pay attention to that, because even the streaming of clips from Russia Today or Sputnik on a social media service is today banned by the EU. There's also a ban that the EU imposed so far, not the UK, on the export of luxury goods, anything from wine to champagne to watches and what have you. Various goods of that nature, articles over €300 cannot be exported to Russia. And also the EU imposed a ban on imports of steel and iron products from Russia. For some reason, that hasn't been introduced yet by the UK, but this is a relative minor issue, although it can be significant. And a general ban was introduced on any investments relating to Crimea. So this is really to give a flavor and a big picture of the extent of the sanctions that were imposed over the last month on Russia. They are varied. They touch on different aspects of not just business, but life in general. And they're very, very significant. Now, next, and we'll move to the next slide, I want to spend a few minutes focusing on the issues that are more relevant to business and the risks for doing business with Russia. So most of these sanctions, as you've seen, are of concern to the banking industry. The banking industry needs to be very, very focused on a lot of these sanctions and organize itself accordingly. But in relation to the rest of the economy, the rest of the businesses, what really matters most is the trade sanctions, predominantly the trade sanctions. And these were expanded dramatically, as I say, after February. Before, we were talking only about targeted sanctions against the oil and gas extraction and exploration sector, which of course are important, for example, for Norwegian companies if they have activities in Russia, but now it goes much beyond. So I mentioned the issue of loans. There's now very extensive prohibitions on granting or arranging loans, firstly to the Russian government and anyone related to it. Secondly, to listed entities. These listed entities are not actually extensive. They do include all of the main big Russian banks and also a number of large oil and gas companies like Gazprom and a few other energy-related enterprises. So there's a ban on lending to these entities, and this ban is limited to loans with a maturity of at least 30 days or more. But more than that, there's now a ban on lending or arranging loans to anyone, any entity at least, connected with Russia. That is extremely broad. That particular ban doesn't include individuals. It applies to companies, but any lending of money for more than 30 days to a entity connected with Russia is now banned. What constitutes exactly connected with Russia? And there are a number of exceptions in relation to subsidiaries outside of Russia is a matter of detail, but that is a very powerful measure that is taken against the Russian economy. Beyond that, Larry mentioned that the US expanded its own export controls in relation to 7 categories of 7 of the main categories of classified goods, and that applies also to the UK and the EU. We call it here critical industry goods, and there's now trade sanctions in relation to critical industry goods and also in relation to aviation and space technology. And I will expand on that because that is something that is probably going to be of interest to almost every company that does business with Russia. It's one of the most extensive, together with the lending issue, it's one of the most extensive sanctions in terms of doing business with Russia, and that needs a bit of explanation. So now, just as a general point, there's a total ban on the exports of military goods. There's a total ban on the export of dual-use goods. Before that, they were just controlled. They were subject to dual-use use, were subject to export controls. But now there's a ban on and dual-use goods are a very significant list of goods and technologies that can be used for both military and non-military purposes. So there's a complete ban now. There's a ban on the export of critical industry goods and on aviation and space technology and related services. So I'm going to expand just a little bit about these last categories, which are quite important. So next slide, please. So what are these critical industry goods? Larry mentioned 7 categories. So we're talking about actually lists, very detailed lists of types of goods, and they fall generally into the bullet points that are listed on this slide. So we're talking about electronics, computers, telecommunications, IT security, optics, sensors and lasers, marine and navigation, avionics, aerospace and propulsion. So within each of those categories, there's long lists, or not necessarily long, there are lists of articles that are treated as critical industry goods. But for example, if we're talking about aerospace and propulsion, this covers any aircraft and any engine. If we're talking about marine, we're talking about any ship, any motor for a ship, and a lot of other things. When we talk about navigation or avionics, we're talking about basically any navigation equipment, any avionics equipment, that is electronics used for aircraft. Again, with most of these categories, we're talking pretty much almost all elements that can be included in these broad categories of goods. Not any electronic or telecommunication systems under the sun, but for example, telecommunications, pretty much any radio equipment is banned except consumer products. So you can still send, you can still export iPhones to Russia and the software that runs on them. But if it's not a consumer product and it's telecommunications, the likelihood is that if it's not a personal telecommunication device, likelihood it is subject to the export bans. Same thing with computers and electronics, very, very extensive. There's a separate category of aviation and space technology, which, as opposed to the others, the export controls in relation to the aviation and space technology includes not just the goods themselves, but all parts and subsystems of those technologies. So any part of an aircraft is now subject to export bans from the EU and the UK. And in relation to, just as in the case of the US, in relation to all of these categories, we're not just talking about the physical goods, we're talking about the software and the technology. And very significantly, we're also talking about services. And for that, I will ask to move to the next slide. Thank you very much. So just to recap, we have these export controls in relation to military goods, dual-use goods, critical industry goods, and aviation and space technology. Now, in relation to each of those, in addition to the bans on the export of goods, software, and technology to Russia, the UK and the EU also have a very significant element of prohibitions on provision of services. And I think that is the area where a lot more businesses are going to be affected, because it's not just exporters, it's not just if you export goods to Russia. The provision of services can touch upon a much wider pool of businesses. So in addition to provisions on the export and the supply and the delivery of restricted items, all of these things are restricted items to Russia. There are prohibitions on the provision of relevant technical services, technical assistance services in relation to these kind of goods, the provisions of funds or financial services in relation to these kind of restricted goods, the provision of funds and financial services relating to technical assistance, and the provision of brokering services and the provision of insurance services. So these prohibitions are extensive, and from the experience of talking with quite a lot of clients over the last few days, I can see that this is the area where people do not expect the sanctions to extend, and where the extent of these sanctions is pervasive. It goes everywhere. For example, financial services. Any company that is in the financial services sector, which could be corporate finance, banking, accountancy, a lot of different things. There's no complete ban on providing financial services to businesses in Russia, but when you think about the vast scope of areas that are covered by critical industry goods, or dual-use goods, or aviation and aerospace, the scope is very large indeed. And if the sanctions do not just apply to the export of goods or software technology, but also to the provision of related financial services, brokering services, etc., that leaves very little to escape through the net. There's still important areas like food and pharmaceuticals, for example, that are not directly affected by the sanctions. But if you are providing services in relation to even food, I advised the client just the other day about some technical services that are related to food manufacturing in Russia, and it's really difficult to avoid the scope of the pervasive scope of those sanctions in relation to services relating to technical assistance, or sanctions on providing technical assistance, because even in the food sector, there's a lot of use of things like electronics and sensors, for example, and all sorts of things. So it is quite difficult to avoid these sanctions now. It's a couple of other elements in which the sanctions are expanded. We're talking about the provision of those services, financial services, technical assistance, and so forth, at different levels, both to persons connected with Russia. So it doesn't have to be in Russia. It is there's a prohibition on providing these services to companies that have Russian connections, and what that amounts to, it depends. So it could be subsidiaries of Russian companies, or companies that are owned by Russian people. So a lot of, and there's of course a few exceptions here and there, and also in relation to activities in Russia. So again, a very extensive scope of prohibitions on the provision of various services relating to various goods and services, with sometimes limited connections to Russia. In addition, the legislation, at least in the UK, in the EU, when it comes to enforcement, the legislation leaves it for each country to have its own laws. So the precise definition of criminal offences and so forth is something that's done on the national basis. But the way it's done in the UK, there's also prohibitions on circumvention and facilitation of acts that are prohibited by the sanctions, and that is simply a device that makes it easier to prosecute, and it's intended to be that way. So if you're thinking, oh, I'm not doing exactly this, I'm doing something slightly different, you have to take into account that acts of circumvention or facilitation, and you can see in the last slide, these words are used also in conjunction with language such as acts having directly or indirectly the object or effect of, so forth. So there's object and effect of, providing funds or financial services to in relation to restrictive activities. All of these are ways in which legislation expands the prohibitions, and indeed expands the criminal offences that are can be committed if these sanctions are violated. So to wrap up, please, next slide. Thank you very much. In terms of, I want to say just a few words about the territorial effect, and the also the criminal offenses that are introduced under these sanction regimes. As opposed to the US, there isn't an express extraterritorial effect to the sanctions imposed by the UK and the EU, but that doesn't mean that the sanctions are narrowly limited to what you do within the UK or the EU. In general, the activities that are caught by the jurisdiction of the sanctions regime include anything done within the territory, any activity done within the territory of the EU or the UK, including on board of aircraft and vessels that are under the jurisdiction, and of course in the territorial water and so forth. Anything done by nationals or passport holders of EU member states or the UK. So you can, it could be an activity done in Brazil or in South Africa by a local company, but if it's done by a person who is a UK or French national or passport holder, that could be an offence. It applies, of course, to any entities that are incorporated in EU member states or in the UK, regardless of where they operate in the world. It also applies to, in relation to any legal person or company or entity in respect of any business activities that is done through the UK or the EU. So if the business activity involves a ship going through the EU and the UK, or a ship insurance being taken in the UK, in the EU, and so forth. So any activities, if the subject matter activity is done partly in the UK or the EU, that could trigger the jurisdiction as well. Importantly, particularly for financial businesses, the sanctions, most of them, and it is done in stages, have been extended to British overseas territories. So there's a general practice of extending UK sanctions to British overseas territories, and the same applies also, by the way, to French overseas territories and Dutch overseas territories. So British overseas territories include the Cayman Islands and the BVI. So a lot of companies around the world, particularly in China, of course, but in many other places, have holding companies in the Cayman Islands in the BVI. So that means that these holding companies, or indeed banks and other institutions that are incorporated through these offshore jurisdictions, they're also caught up by the sanctions regime by reason of the sanctions regime being implemented in those territories. So that is another expansion, in some cases, a significant expansion of the sanction regime. As I said, violations of the sanctions are criminal offences. If companies commit violations, they are subject to significant penalties. If individuals commit penalties, they commit offences, they are subject to prison sentences. And finally, very important on the business side, officers and directors, or indeed any employee of a company, can commit an offence if an offence by the corporation is committed with the consent or connivance of the employee or the officer or the director, or attributable to any negligence of that director or officer. And I said director or officer, it really actually applies to any person employed by the company. So again, a huge expansion of the potential criminal liability for activities that contravene the sanctions. So with that, and we are almost out of time, but we have 5 minutes for a few questions if you have any. We conclude. As you can see, we're talking now about very, very extensive sanctions, and the whole point of these sanctions is to make everyone around the world think 3 times before actually doing business with Russia.
Thank you, Ron. I think your talk has been so comprehensive that everyone's questions have been answered. So we haven't had any questions. We can, if anyone has any questions, please put them in the chat in the next 30 seconds. Otherwise, we'll wrap up there. We'll just give it a few seconds, see if anyone asks anything. without any questions, I'd like to say thank you very much to Kyrre and the NBCC for collaborating with us on this today, and thank you very much also to Ron and to Larry for that comprehensive run through of sanctions in the US and the EU and the UK. And we've just had a question from Omi, who asks about contracts and force majeure in the context of sanctions. It's probably one for you, Ron.
Yeah, well, I will mention, I mean, obviously, there's a lot of commercial issues at the ancillary to the sanctions regime, but I will say one important thing. The legislation in the EU and the UK expressly provides that anything done in compliance with the sanctions cannot be the subject of legal claims. So you don't even need a force majeure provision in your contract. If you have a contract and acting on that contract would contravene the sanctions, you're not going to be subject to any legal claims in the UK or in the EU for breach of contract. Now, you might be subject to a breach of contract claim in Russia or perhaps in other countries, but as far as EU and UK law is concerned, there's a complete protection or immunity from legal liability for compliance with the sanctions regime. Another thing I would say, which is perhaps the flip side of that, or not exactly the flip side, but in many areas of sanctions, not just in relation to Russia, there are evergreen kind of clauses that say that protect people's ability to carry on with contracts that were signed before the sanctions were introduced. That was also very much the case in relation to Russian sanctions or the sanctions against Russia until 2022. The new sanctions do not give those allowances. So except in very limited respect. So in respect for loans that were granted before the 1st of March, those loans can continue to be serviced, and this is fine. But for example, if you have a contract for servicing an oil rig in Russia or some other installation, which is now covered by the sanctions against providing technical assistance, there's no allowance now for continuing to perform under this contract. You have to default on the contract, and you will be protected from liability under UK and EU law. Now, of course, as in every contract should have or any contract for work should have a force majeure provision, and usually if the imposition of sanctions would be covered by force majeure clauses, but that of course depends entirely on the drafting, and sometimes force majeure clauses include conditions and various requirements. So this is something to look at very, very closely, particularly if you're not subject to UK or EU law.
And I would just add, from the US perspective, we don't have the same law that would limit liability that the UK has. However, practically enforcing a contract breach because of compliance with US sanctions laws just would not obviously happen in our court system. And what we've seen, particularly when it comes to contracts involving Russia or other regions that have become the target or potential target of sanctions in recent years, is removing the language from the force majeure clause and actually putting in a robust clause regarding sanctions programs and regarding the ability to terminate immediately if a sanctions program were to prohibit continuing work under the contract. So I think that is one potential workaround that we've seen that has been successful.
I know that we're out of time, I believe, so there is another question. I'm not sure we have time to respond to it.
Yeah, Ron, I think we'll call it there, and we've had 3 more questions actually, but we'll pick those up with you guys individually who've asked them subsequently. I hope that's okay with everyone. And yeah, thanks everyone again. Thanks to the NBCC for collaborating with us, and thanks everyone for attending.